Let's dive right into this explainer. Have you ever felt completely out of luck when someone owes you money and just refuses to pay? Well, today we're breaking down a highly practical and empowering topic, exactly how to file a small claims case in the state of Florida. Whether you're a tenant trying to pry your security deposit out of a landlord's hands or a small business owner chasing down a painfully overdue invoice, the legal system can seem really intimidating. But listen, it honestly doesn't have to be. We've combed through all the Florida statutes, the court rules, and the official guides to build this step-by-step explainer just for you so you can resolve your disputes without needing an expensive attorney.
If you have been wronged and you're owed money, the Small Claims Court is your arena. It's specifically designed for everyday people to seek justice directly. Think of it as the People's Court. The whole purpose of the Small Claims Division of the Florida County Courts is to give you a process that is simpler, way faster, and much more informal than regular civil court. You absolutely don't need a law degree to succeed here. But you definitely do need preparation, organization, and a solid grasp of the rules of the game.
So to make this as easy as possible, we're going to follow a straightforward 6-step journey. Small claims court basics, preparing to file your case, filing and serving papers, mediation and trial prep, the court hearing, and finally, post-judgment actions. All right, let's hit step 1, small claims court basics. We need to figure out if your case actually qualifies. Before you spend a single ounce of energy or a dime of your money, here is the most crucial thing to remember. Your claim has to be for $8,000 or less. The court has very strict boundaries on what it can handle, and $8,000 is the absolute ceiling for small claims jurisdiction in Florida. Now, a quick heads up on that limit completely excludes your court filing costs, any accumulated interest, and attorney's fees if those apply. But if your actual damages are, say, $8,001, you legally cannot use this simplified process. You'd be forced into the regular county or circuit civil courts. So, who gets to file, and for what exactly? Well, anyone 18 or older, or a business entity, can file to recover quantifiable monetary losses. And quantifiable is the magic word there. This court is for actual money and tangible property. It is not for abstract grievances or trying to get the judge to force someone to finish a paint job they walked out on. We're talking about things like auto negligence or property damage, personal loans that were never paid back, landlords unfairly holding onto a security deposit, or a straightforward breach of contract where you paid for goods or services and never got them. Moving right along to step 2, preparing to file your case. This is all about gathering your evidence and finding the right court. Okay, now that you know you qualify, it's time to gather your armor, but you're on a ticking clock. Florida law has this thing called the statute of limitations, which dictates exactly how long you have to file a lawsuit after an incident actually happens. If it's a written contract, you generally have 5 years. For a verbal contract or general negligence, it drops to 4 years. And for property damage, you have a really tight 2-year window. And trust me, if you file too late, the judge will issue an automatic dismissal, and it won't even matter how rock solid your evidence is. Assuming you're within that time limit, your next step is to build an airtight evidence binder with a very clear timeline. Remember, the burden of proof is entirely on you. You're the plaintiff. You've got to gather every single contract, invoice, text message, and photo that backs up your story. Plus, it is highly recommended that you send a written demand letter to the other person before you file anything. Just send a certified letter or an email spelling out exactly what you're owed and give them a firm deadline to pay. It shows the judge you operated in good faith and tried to avoid a lawsuit in the first place. You also have to pinpoint exactly where to file. You can't just pick the courthouse down the street because it's convenient for you. You have to use the defendant's exact legal name and file in the proper venue. Under Florida rules, that usually means the county where the defendant actually lives, where their business operates, or where the dispute physically happened. If you file in the wrong county, your case gets transferred or dismissed, which is just a massive waste of your time and money. Pro tip for suing businesses: use Florida's SunBiz website to find their exact registered corporate name. That brings us to step 3, filing and serving papers. You are officially crossing the threshold into the legal system. Once your paperwork is absolutely flawless and you know your venue, it is go time. Your dispute officially becomes a lawsuit. You'll file your statement of claim with the clerk of court, either in person or right online through Florida's e-filing portal. Now, there is a tiered filing fee based on how much money you're actually suing for. It ranges from about $55 for a tiny claim all the way up to $400 if you're maxing it out at $8,000. But if you genuinely can't afford those fees, you can apply for indigent status with the clerk. If you qualify, they'll actually waive or defer those fees for you. But just filing the papers with the clerk isn't the end of the story. The court has absolutely no power to act until you successfully complete the service of process. This is a fundamental constitutional safeguard. Basically, it means delivering the official notice to appear summons along with your claim directly to the defendant. It guarantees they know they're being sued and gives them a fair chance to defend themselves. So, how does that actually work? Well, you can't just march up to them and hand over the papers yourself. That's a huge no-no. Instead, you'll typically pay around $40 to have the local sheriff's office or a certified private process server hand deliver everything to the defendant's home or registered business address. In a few specific counties and for certain defendants in Florida, you might be allowed to use certified mail with a return receipt. But honestly, having a professional personally serve them is the absolute gold standard to make sure your case doesn't get derailed by some silly technicality. All right, let's jump to step 4, mediation and trial prep. This is going to be your first face-to-face meeting. Awesome, your claim is filed and the defendant has officially been served. Next up, both of you will be summoned to a pre-trial conference. Don't panic, this is usually just a super quick 5 to 10 minute meeting. In Florida, if the defendant actually shows up and denies they owe you anything, the judge is almost certainly going to send you to on-the-spot mediation. This is an incredibly valuable and free service where a neutral, professional mediator sits down with both of you to help hash out a settlement, entirely avoiding the stress of a trial. They don't decide who is right, they just help facilitate the conversation. Believe it or not, a huge chunk of small claims cases are resolved right then and there. But let's say mediation totally fails and nobody budges. Now you're going to trial. And here is a critical warning directly from a Florida judge's official notice. You absolutely must bring physical copies of all your evidence. I mean the original for you, one copy for the judge, and a second copy to hand to the defendant. And here is a modern twist you definitely can't ignore. If your evidence involves digital photos, a video clip, or a string of text messages, it is 100% your responsibility to bring a laptop or a tablet to show those files in court, plus a way to leave a physical or digital copy with the clerk. Which brings us to step 5, the court hearing. Time to present your case to the judge. Trial day is finally here. Small claims court might be informal, and you rarely see a jury, but it demands total respect, extreme organization, and a strictly factual presentation of the money you lost. Show up at least 30 minutes early. Always, always address the judge as your honor. Keep your opening statement incredibly brief, like under 2 minutes, just telling the judge what happened and exactly what you're owed. Present your timeline chronologically. If you bring witnesses, make sure they have first-hand knowledge. A mechanic who literally inspected the damage on your car is perfect. Your buddy who just heard you complaining about it, useless. And whatever you do, stay calm. Hostility or emotional outbursts will alienate the judge instantly. Just keep in mind that the plaintiff always gets to speak first, and then a defendant gets their turn. The judge will listen, they might ask a few clarifying questions, and they'll review your exhibits. Whoever provides the most coherent, authenticated evidence is usually the one walking away with the judgment. Theatrics, passion, and anger, they don't win cases. Receipts, contracts, and a perfectly logical timeline, those win cases. And finally, step 6, post-judgment actions. Let's talk about actually securing your reward. So you won. Congratulations, the judge ruled right in your favor. But I hate to break it to you, we are not quite done yet. This is probably the hardest truth about small claims court. A judgment is just a piece of paper signed by a judge. It officially declares that you are owed this money, but the court does not write you a check. If the defendant doesn't voluntarily pull out their checkbook right after the trial, the burden is 100% on you to enforce that judgment. Thankfully, Florida gives you some incredibly powerful legal tools to force their hand. You can file for wage garnishment, which means the court orders their employer to siphon off up to 25% of their paycheck and send it directly to you. You can levy their bank accounts. You can even slap a judgment lien on their real estate, meaning they literally can't sell their house without paying you off first. And if they're hiding their money, you can force them into a post-judgment debtor examination under oath. Just keep in mind, there are certain legal protections you have to navigate, like you usually can't garnish the wages of a head of household who provides more than half the financial support for a dependent. Okay, before we wrap this up, I need to throw in a quick disclaimer. While the Florida small claims system is beautifully designed for self-representation, the law is always full of nuances. This explainer is strictly for educational purposes to help you get the lay of the land. It absolutely does not constitute formal legal advice. You should always consider consulting a qualified attorney or swinging by your local court's self-help center to get specific legal guidance tailored to your exact situation. From the outside, the legal system can seem like this massive, intimidating machine. But with the right prep work, some diligent documentation, and a cool head, getting a fair resolution is entirely within your reach. You really don't have to just walk away from money you're owed simply because you don't have a lawyer on retainer. Knowing the rules is your biggest advantage. So if someone is sitting on money that is rightfully yours, what is stopping you from taking that first step today? Thanks so much for joining me on this explainer. Keep learning, keep your receipts organized, and I'll catch you on the next deep dive.